Hi, I'm Laura Hollis. I'm a clinical professor of business administration, and I teach law and entrepreneurship in the colleges of business and engineering here at the University of Illinois. Today is the first in a series, 9 points in 9 minutes or less. Today's topic is 9 things to know about an employment contract before you sign it. First point, once you've signed any contract, the law assumes that you've read it and that you understand it. So the first most important thing to know about any contract is that you have to read it before you sign it. You'd be astonished how many people don't read a contract before they sign it, or if they do read it, they don't understand it. If there's anything you don't understand in a contract, employment or otherwise, you want to make sure you get legal advice first. Second point, watch out for language like attached hereto and incorporated by reference herein. It's not enough oftentimes to read the contract itself. Sometimes other documents like employee or personnel handbooks will be made a part of the employment contract. So you have to read those too. Once you sign the contract, the law assumes that you not only understood the terms of the contract, but any other documents that are incorporated into it. Third point, what does the company own? Be on the lookout for terms like shop rights and work for hire clauses. The shop right refers to your employer's ownership and or right to patent anything that you invent, develop, create, or conceive of while you're in their employ. Work for hire is a similar provision, but it refers to your employer's copyright interests as opposed to patent rights. These clauses are often drafted very broadly, so it could refer to anything that you think about, dream about, discuss with anyone, write down or doodle anytime over the term of your employment with this company. That includes anytime you're at home, on vacation, elsewhere. So you want to read these carefully to make sure that you avoid disputes over ownership later. Fourth point, choice of forum clause. This is one of those clauses that most individuals don't understand, and a lot of times they don't even read them when they sign a contract. These types of clauses are only triggered in the event of disputes that result in litigation, and one of the biggest surprises is finding out that you are stuck litigating in a state that could be quite far away from where you live or work. A choice of forum clause is a clause in a contract that indicates where the litigation will take place in the event of a dispute. These are very common with large, national or multinational corporations that have offices all over the country, but they want the litigation to be located in their corporate headquarters or where their legal department is located, which may or may not be in the same state where you work for them. Ditto for what's called a choice of law clause. These are clauses that provide which law governs the dispute, as opposed to where the dispute's going to be litigated. Now, this may not seem like a big deal, but it can often make a very big difference in the outcome of litigation. The law of the state your employer has chosen to govern any dispute may be much less favorable than the law of another state, such as the state where you live or the state where you work for this employer. Choice of forum clauses and choice of law clauses are what we call boilerplate language. This means standard form language. Frequently it's picked up and lifted from form books and incorporated into contracts, and you'd be surprised how often the other party to the agreement doesn't understand these clauses. Sometimes they haven't even read them. This point, number 6, a contract can bind you after you leave to non-disclosure agreements. Non-disclosure agreements are provisions in your employment contract or other contracts which are intended to protect your employer's intellectual property, trade secrets, customer lists, formulas, basically anything that isn't public knowledge but which gives your employer a legitimate competitive advantage. A non-disclosure agreement prohibits you from revealing any of this confidential or proprietary information to anyone at any time during the course of your employment or afterwards. Non-disclosure agreements, unlike some other provisions in contracts, are generally looked upon favorably by courts and are enforceable. Let's contrast that with what we call covenants not to compete. A covenant not to compete, unlike a non-disclosure agreement, prevents you from working for one of your employer's competitors. You have to watch out for these. They should be for a reasonable length of time, for example, 6 months to a year, cover a reasonable geographic area, and be reasonably necessary given your job title, your responsibilities, and the access you had to confidential information while working for your former employer. The more access to confidential information you had, the more likely it is that a court's going to enforce a provision like this. The less access you had, the less likely it is that a court's going to enforce it. Courts tend to construe covenants not to compete fairly strictly. The argument against them is that they cannot deprive an individual of their livelihood. But remember what I said about choice of law clauses a couple of minutes ago. Some states' laws are much more favorable to employers than to employees. For example, the state of Illinois tends to take a very broad approval of covenants not to compete. Other states tend to favor the employees. 8th point, one of the most important. Remember, the time to negotiate any of the terms of an employment contract is before you've signed it. Believe it or not, everything is negotiable, but you can't negotiate if you haven't read the contract or you don't understand it. So this brings us to our 9th point, which is cheating a little bit because it's actually the first point restated. Most important thing about any contract, but certainly an employment contract, is to read it before you sign it. That wraps it up for this one. 9 points in 9 minutes or less. See you next time.